Hi, good afternoon. I'm Shelly Miyashiro, and I just want to say I'm just very honored and humbled to be a part of this conference. This is my first conference, and just having attended the opening, the two prior sessions, again, it's just a humbling experience to be in the presence of such wonderful people who do such awesome work for our community. So I'm here today to talk a little bit about what prosecutors do regarding domestic violence cases. My office does take a multidisciplinary approach that is victim-centered. And when I first signed up for this, I knew I had to put a team together because I can't talk about taking a multidisciplinary approach by myself. So I have a very important person with me, Chelsie Takasaki. She's one of our advocates, and I will let her introduce herself first.
Hi, good afternoon, everyone. Thank you for having me as well. My name is Chelsie Takasaki. I am one of the victim witness counselors at the prosecuting attorney's office in Maui County, but they also refer to us as advocates as well. So we are going to be discussing justice and accountability with a multidisciplinary approach to prosecuting domestic violence cases. So we hope that you are able to learn something new in this presentation, and feel free to post in the chat during our slides if you have any questions in the meantime.
So before we begin, I just want to explain some of the terms that I use and why I use them. Throughout the presentation, I will refer to the survivor as the victim. I will refer to the abuser as the offender. And the reason why I do that is when we get police reports, that's how the parties are identified. That's how I know which party has been harmed, which party is responsible and should be charged. So Chelsie and I are really sharing from our experiences. And the first thing that I want to do is really talk about the responsibilities of a deputy prosecuting attorney, or the role of a prosecutor. And, these are taken from the National District Attorney Association standards. It's a prosecutors organizations that puts forth standards, guidelines, best practices. So a prosecutor is really an independent administrator of justice. Our primary responsibility is to seek justice, and this can only be achieved by seeking the truth. One of the things we do is we ensure that the guilty are held accountable. We ensure that innocent victims are protected from unwarranted harm. We also ensure that the rights of all participants, in particular victims of crimes, are respected. We represent society as a whole. We don't represent the victim. We don't represent the county or the individuals. We represent the people or the community. In doing our job, we need to exercise independent judgment. So what that means is we can't look at do something because of our interest or because we think it will benefit someone else. We do take into account everyone's interests, the victim, witnesses, our police officers, suspects, defendants, and even members of society. So what this means is when I make a decision, if I see something that is a violation of constitutional right, and I don't have evidence to proceed, then I should not be charging the case or prosecuting the case, even if I feel that a defendant or offender is guilty. So that's just one of the interesting parts about being a prosecutor is we do want to protect the community. We want to protect our victims. But because of our role in the criminal justice system, we also have to protect the rights of defendants.
And so I'll be discussing when I step in as a victim witness advocate. So essentially, our role is just helping victims and witnesses navigate the criminal justice system from beginning to end, since more often than not, people are unfamiliar and this might be their first time learning about the entire process. Victims are already so overwhelmed because of their certain situation that caused that police report and that incident to trigger. So we just want to make it as easy as possible for them. So to say that, there's a support person from the beginning of your case that knows what occurred for the incident, has built some rapport with you, and it's just kind of helpful as a liaison between them and the prosecutor. So we'll do things like provide referrals and discussing with our clients what are things that you and your family need at this time. Some people might be requiring things like, oh, how do I file for a restraining order? Or myself and my family are really interested in seeking counseling. And of course, there's other needs as well, but for those, then we do refer out into the community. We also give an explanation of the court process. Some people want all that information from the beginning. Some people want to hear about it only as it comes. So kind of just playing by ear what each victim is interested in and how they want to go about this process. And we'll go from there and help them. And we also are notifying them of court events. So things like when a defendant has their pre-trial conference, which is a point in time where defense and prosecution will go in front of the judge to explain if they are ready for trial. Sometimes there's multiple pre-trial conferences before an actual trial date is set. Some victims do want to have information about each court hearing and finding out what occurred. Some, just don't want to know anything, don't want to deal with it until they have to get involved if they have to come to court for a trial. So sometimes some clients, for their own self-care, ask that if I'm not needed, please do not reach out to me, please do not talk to me. And some really want that deep involvement. We also accompany our victims as well as witnesses to court. They might be going to court for things like a grand jury hearing, a preliminary hearing for trial, or coming for a sentencing hearing. And we offer ourselves, or if unavailable, another advocate can go in our place, just so they're not alone. People sometimes want to bring a support person that they know personally, and some people want to keep the situation a bit more private and want that support from the advocate instead. We also are facilitating the availability of witnesses and victims for trial and their hearings. So sometimes that means helping with coordinating transportation. Sometimes it includes if someone is a tourist, in some situations, they are eligible for something called a return witness program. And in that situation, that's for victims that were a victim of a crime in Maui County, but they were not a resident here and they were a tourist. And so for some situations, they do qualify, and there are relationships we have with things like the the Hawaii tourism industry, just to kind of coordinate some things like for places for them to stay and just lightening the financial burden of their return to Maui. So it's not so much of a burden on the state. Also, we support with victim impact statements. And so that is something that all victims have the right for if the case is one that there is a conviction for. So at a sentencing hearing, a victim does have the opportunity to go in front of the judge and provide a victim impact statement so they can address the courts directly, let them know how the case and the situation with the offender has affected them. And it's their time to just say whatever it is that they need to say about it. Some people choose to go to these hearings and speak. Some people choose to go to these hearings just to observe, don't want to say anything, and some people are not interested in coming to sentencing. So we do support our victims, no matter what their interest or non-interest is, during this process. We also assist with things like restitution and crime victim compensation applications, which I'll discuss later in the presentation.
So we have about, when we're full staff, 40 attorneys or 40 deputies in our office. We have a family court team, a domestic violence team that consists of 4 deputies who handle adult family criminal cases. As a side, we do have 1 deputy who handles the juvenile calendar. But the deputies who are assigned to the DV team handle primarily abuse cases, and it could be petty misdemeanor abuse, or even felony abuse. There are also violation of TRO or order for protection cases and custodial interference cases. In addition to the adult family court criminal cases, they handle other felony cases, whether it's crimes of violence or property crimes. I checked our records, our stats. Last year, from January 1st to December 31st, we received over 800 cases that had that were labeled as with a domestic violence attribute. And this means it could be a crime of violence involving spouses, boyfriend, girlfriend. We also, this also includes over 500 family adult cases. So again, the cases that would be charged and appear in front of the family court. I just wanted to talk a little bit about what kind of offenses we're dealing with, primarily for the abuse statute. The abuse statute defines who is a family or household member. And this is set forth in Hawaii Revised Statute 709-906. And this is the section, that the deputies will often refer to. This is the law that we need to follow. Family or household member does, include spouses or even formal spouses. People in a dating relationship, sometimes that's, a question of fact the jury may have to figure out. Does not include casual relationships or acquaintanceships. It also includes people who have a child in common, people jointly residing other than roommates. So if there's no rental agreements, but they're living there together, they might fall under the family or household member. When we think of domestic violence, we think of spouses, boyfriend, girlfriend, but the abuse statute also covers persons related by consanguinity. So if you're related to someone, brother, sister, your auntie, your uncle, those relationships may also fall under family or household member. So what is abuse? Abuse is a whole variety of acts, and some acts are more serious than others. In subsection 6, this is a petty misdemeanor offense. It's when someone intentionally or knowingly strikes, shoves, kicks, or touches someone in a family or household member in an offensive manner. Or you could subject a family or household member to offensive physical contact, or if someone exercises coercive control. So I just want to say that for attorneys, when we talk about the grades of offenses, what we're really looking at in doing so is what kind of punishment. Petty misdemeanors is a lower level offense. A maximum penalty could be 30 days jail, possibly short term of probation, compared to a felony, which could involve 5 years prison, 10 years prison, sometimes 20 years to life. So coercive control, I believe this is a newer statute. And these are some of the actions that it involves: threatening, humiliating, intimidating, taking away a person's liberty or freedom, isolation, controlling finances. And when we look at this definition, what's really interesting is that it does follow the power and control wheel. And I'll ask Chelsie to kind of talk a little bit about that.
So The wheel of power and control are some things that are factors that are keeping our victims under the power and control of their offender. So, let's start with economic abuse. Maybe this person knows that with their salary, they are not able to afford even a studio apartment. And they might think that my situation is really hard right now with this offender, but it's so much worse if I'm homeless. It's so much worse because if I'm struggling with housing, how am I supposed to go to work the next day if I'm not getting good sleep, if I'm so stressed about these other things? For coercion and threats, someone might say, oh, if you don't listen to me, then I am going to tell everyone this about you. Doesn't have to be true, but sometimes that threat or that coercion is something that our victims consider as a situation where, I don't want all of these things to get out. I don't want the things that the offender is telling me to be known outside of just my immediate family, just myself. So those threats can be effective. And then that also falls in line with that intimidation aspect. And I think that intimidation point kind of includes everything else within the wheel. So emotional abuse, sometimes it is a cycle of violence where there are people who have seen growing up other unhealthy relationships. If you grow up in an environment where an unhealthy relationship, where someone is yelling at you, calling you stupid, calling you names and just belittling you is something that you consider just a normal part of a relationship. There's good days where the person's really nice and they might be getting loved bombed by that person, which is just an excessive use of affection and kind of that little carrot to say, oh, I want that positive affection. So although there are these times that are so negative when they treat me this way, I know that they're a good person because of those points in time where they feel those small bits of love. Isolation. So for that, there are people where they are in a town that they're unfamiliar with. Sometimes there are transient people who come to the islands and they might say, I do have family, but none of them are here. I do have friends, but none of them are here. Sometimes there is a situation where a person does have family and friends locally, but the offender isolates them and cuts off those other relationships. Sometimes it's slowly, sometimes it's an ultimatum. But having less of those opportunities of other avenues of support, other people you can talk to, rely on, that isolation only brings the offender's ability to control the victim. It just increases those chances. And then minimizing, denying, and blaming. In that situation, you might be thinking, oh, this person, my spouse, they hit me on the head. That's not cool. And the offender might say something like, oh, it wasn't that big of a deal. You know, I'm sorry I hit you on the head. It was an accident. Minimizing. Another time they might say, I'm sure you were really drunk. I don't think that happened. Denial. Blaming might be saying, yes, I did hit you and you deserved it. So we have to just think about how all of these points within the wheel kind of start to intertwine and have layers that intersect. Next up is using children or pets, and I would say that pets are another version of your children. I have fuzzy loved ones myself, and I would just as much say that they are my children. For some people, they do receive threats towards their loved ones, like their children, pets. Sometimes it's other people that they care about. And they think, and a victim might be saying, I have a really strong connection with perhaps my stepchildren, perhaps the offender's pet. And I know that if I remove myself from the situation, I cannot help because they're technically not my family, technically not my pet. Sometimes it is a situation where the child is the offender's biological parent. So they also think, oh, because they're the offender and my child, I don't want to lose custody, or I don't want 50% custody. So wanting to maintain that relationship with those loved ones is another aspect that these offenders are able to use to control. And then finally, using privilege. I am a woman, and I know through my life experience that there is male privilege. I also know as a woman who's a minority that there are privileges that I have for being Asian, but there are also some things that I don't have compared to the standard white male cisgendered privilege. So, you know, for these offenders, they have so many um, different nuances, but they will use their aspects of privilege to use that as a means of control, as a means of authority. And so for our victims who are within this entire encompassing wheel, it's not just one factor that is affecting them. And when they get beaten down emotionally and sometimes physically, it's really hard to see that there is something beyond the wheel.
So, by going through the abuse statute, I just want to point out that over the years, the definition of what constitutes or what is abuse has changed. So, even some of the acts on the power and control wheel could be petty misdemeanor abuse. And I just want to share that, I started in 2002 with the Office of the Public Defender. And my first assignment was the family court adult calendar. And it was primarily abuses, and that was misdemeanor abuse. When I did my first jury trial a couple years later, the facts suggested that a strangulation had happened. But at that time, it was still considered a petty misdemeanor abuse, excuse me. And a misdemeanor abuse is usually, I think, what the deputies see a lot of. It's when someone causes injury, hurt, or damage to another person. So if there's pain, bruising, essentially anything short of broken bones and serious injuries. The penalties are pretty stiff compared to other misdemeanors in the sense that for a first offense, there is a mandatory 48 hours jail. If someone continues to abuse a family or household member, he gets a second offense within a year, then the mandatory jail jumps up to 30 days. There's a third offense within 2 years of his second conviction. We're looking at a Class C felony, and the possible penalty for that is a longer period of probation, 5 years, 5 years, or 5 years prison. Again, what constitutes abuse has changed, and I think it's great that the legislature, the community does recognize that certain acts are more serious. So I believe in 2006, strangulation was made a Class C felony. This is when someone applies pressure on another person's throat or neck, blocks the nose and mouth, applies pressure to the to the chest, making it difficult for someone to breathe or cuts off the circulation of blood. Another thing that I believe is taken more seriously now is what happens when abuse occurs in the presence of family or household members' child. So that now is a Class C felony. The minor has to be less than 14 years of age, and the minor has to actually be present, or the offender has to know that the child may see or hear the abuse. So again, the legislature, the community does recognize that, children are affected by abuse, just witnessing it. And so this type of act, abuse in the presence of a minor, is treated more seriously. I just want to talk a little bit about what happens when someone is convicted of abuse. I think many times people think that the prosecutors are out for blood. They just want to lock people up, throw away the key. But there's different types of sentencing. There's probation, and probation is when someone is out in the community supervised, many times being ordered to do certain things, such as get substance abuse treatment, attend domestic violence intervention classes or anger management classes. Probation also can involve some jail, which is a short period incarcerated. Sometimes when we're looking at Class C felony offenses, person cannot control their emotions, behavior, continues to harm others. There are times when they are looking at prison. And when we talk about prison, we're usually talking about going to Halava, or, Arizona. The person may not serve the full term of prison. They may be paroled, but before they're paroled, they would have to do certain things. Again, probably anger management, and any treatment that is recommended. Just going back again to the responsibilities role of the prosecutor. We have to consider certain factors in making a plea offer or in recommending a sentence. We have to look at the facts of the case, so the nature, circumstances of the offense. We have to look at the history, characteristics of the defendant. Is this someone who has a prior record? Is this someone who can be rehabilitated? We also have to, argue for a sentence that reflects the seriousness of the offense, promotes respect for the law, also provides just punishment. So,
Shelly, there's a question in the chat.
okay. So there are statute of limitations on when we can charge. So I would say, yes, there is a statute of limitations on reporting domestic abuse. For petty misdemeanor incidents, we have to charge within a year of the incident. So not the time it's reported, but the date that the offense occurred. For misdemeanors, there's a 2-year period that we have to charge. And I believe for felonies, there's a 3-year period. So I hope that does answer the question. But again, just going back to certain factors that we need to consider. Again, we do look at input of the, from the victim, concerns the victim may have. However, we can't just say we want a sentence because that's what the victim wants. So, if it's a first offense and the victim wants the full year jail, that's something that's probably not going to happen. That's something that I probably wouldn't ask for, depending on the facts and circumstances. And one of the reasons is, we need to avoid unwarranted sentence disparities among defendants. So we should ask for similar sentences for defendants with similar records. So I think that, domestic violence cases are some of the toughest cases to prosecute. And one of the reasons, could be that, nobody wants to be involved. A lot of times at court, I get the sense, the offender definitely doesn't want to be there. Sometimes you get the sense, the victim doesn't want to be there. I even heard judges say, well, I don't even know if the attorneys want to be there as well. But these are tough cases. And some of the challenges, I've experienced or observed is, in a criminal case, the state or the prosecutor has to prove the offense or what happened beyond a reasonable doubt. That's the highest standard in a court of law in America. And, There are often times when, victims' testimony may be inconsistent or unreliable. And there are reasons for that. It could be the result of trauma. And when the police arrived, maybe the victim didn't have a full sense of what happened, or it could be they were strangled and, they didn't realize, that they blacked out. They don't know how long they were strangled. There are often times that, the victim may also recant, minimize or deny, that any abuse occurred. And again, some of the reasons are what Chelsie talked about in the power and control wheel. Many times, domestic violence occurs in the house or in the home, and there's often no witnesses. It's what the offender says, it's what the victim says. So sometimes the lack of witnesses, it's frustrating and it is a challenge. Also, sometimes there's lack of physical evidence. When people think of abuse, it's like, okay, what happened and where's the injury? However, in strangulation cases, many times there is no injury. I think Chelsea's going to talk a little bit about strangulation later on.
There's another
Other
question,
challenges.
Shelly.
So the question is, how important are accurate police reports in prosecuting domestic violence cases?
I think that accurate police reports are essential. And the police, being the first responders, can really focus on gathering evidence to help make the case to the point sometimes where we are able to proceed without, having the victim come to court. So that's something I guess we can touch base in a little bit, but I will, say that accurate police reports, detailed police reports, thorough police reports are essential to prosecuting these cases. So sometimes I will say what's contained in the police report can be a challenge because there's not enough information. These cases oftentimes go before a jury. And then we're dealing with jurors' perceptions of domestic violence, right? They have a sense of, who's a true victim, and that a victim should behave in a certain manner. They may question why the victim is still with the offender, why they haven't walked away from the relationship. Sometimes they may think, well, you know what, it takes two people to fight, so everybody's responsible. Both are responsible. Again, looking for injuries, there may be none because of the type of abuse, or they may say, oh my God, that injury is not that bad.
So this question is, do you lean on expert witnesses in the cases that pose a challenge based on trauma response, loss of memory?
Thank you. You guys, these are great questions. And we do rely on expert witnesses. In strangulation cases, we relied heavily on Dr. Kepler, who has since retired, but he would come to court, testify about the mechanics of strangulation, the lack of injuries. We also relied on our DV experts. I believe I think most of you have been following the news, and our head prosecutor, Andrew Martin, just completed a trial involving, the initial charge was attempt murder, but it did involve, a minor victim. And in that case, yes, we did rely a lot on a domestic violence expert. We relied a lot on medical experts. Okay. Some of the challenges that we need to overcome are, it's the rights of the offender. It's the rules that we need to follow. So in a court of law, the offender defendant has the right to confrontation, which means that he or she can hear the testimony of the witnesses. So, there are times when, in order to prove a case, we have to bring the witness to court or the victim to court. And again, based on some of the, things that we discussed, victim may not want to cooperate. Also, police cannot testify on behalf of the victim. Hearsay is not allowed. Someone cannot go to court and say, well, hey, Chelsie just told me what happened and whatever she said is true. Now, there are hearsay exceptions, but those are very limited. Another thing that the prosecutors need to follow are the rules of evidence. Many times there are prior acts of abuse. However, we can't bring these up to say that, hey, he did it before, he did it again. There are times when prior acts are allowed, but it's for a limited purpose, such as explaining why a victim may recant, to explain the nature of the relationship, that it is a domestic violence relationship. Other challenges may be sometimes the prosecutor's interests and goals conflict, to the victim's interest. One of our duties, responsibilities is to hold the offender accountable. We have to make sure the victim is safe. We have to make sure the community is safe. The victim, on the other hand, may feel that, hey, it's a personal matter, and they may want to withdraw prosecution. They may not want to go forward with the charges. They may not want to participate in a trial. And there are many times when a victim may want to continue the relationship with the abuser. So they say, no, it's okay. I want him out of jail. It's okay. I want contact. He can stay with me. Do you want to add some more, Chelsie?
I would also just like to add, for the victim's interest, sometimes they want the book thrown at the offender. They will read what the statutes say and will ask for those maximums. So sometimes that might be the year or longer in jail. So although they will be letting us know that those are our wishes, as a prosecutor, Shelly, can you talk about how you would take that request and then be a little bit more realistic to what's possible, depending on the case?
I think, depending on what a victim wants, again, I go back to, my role, that I can't just, argue for something just because that's what you want. There are certain factors regarding, an appropriate sentence. And I have to treat, defendants in his position the same. So just because you want life without, prison, I doesn't mean I can argue that. I am limited to the law, and I have to look at certain factors as set forth in the law.
And then on the opposite side, sometimes somebody does want offense to receive a sentence that's lesser than what the law dictates. It might be a case where someone does have to go to prison, but the victim wants them held responsible, but wants probation or something far lesser. So we also have to balance that. Question coming in is, have you ever successfully prosecuted a coercive control case? And is this a challenge?
I will say I don't believe we've charged an abuse based on coercive control. I know we just attended a training, and the presenters were very excited that this was, included in the abuse statute. I will say that I think one of the things that my office and my deputies will need to do in order to, prosecute these types of cases is really training, and then also training with the police to make sure that we can get the appropriate evidence to prosecute such a case. So how do we overcome challenges for these cases? And I'm so glad that that we're invited to this conference, because I think the way we overcome our challenges is we got to work together. And what that means is, the police have to, be proactive, gather information. The dispatchers also have to, gather information. When the EMTs arrive, they should be trained in trauma, strangulation. They should also be proactive, gather information, as well as the doctors, nurses, counselors are very important. I like to have our counselors be the first contact with a victim. I feel that a victim would rather talk to a counselor than an attorney. Oftentimes when the attorneys are the ones who reach out to the victims first, the concern then becomes, well, what's going to happen to him? Are you charging? Is he going to go to jail? I'd rather victims talk to our counselors because then we can say, are you safe? What do you need? And then we heavily rely on our community partners. I did mention PACT, Women Helping Women. I know I'm missing a lot, but we do have a lot of community partners who provides assistance and services. And then, of course, the prosecutors also are part of the multidisciplinary team.
And then another challenge with the multidisciplinary team is that to an extent, we aren't able to just be completely open and communicate with one another. So for example, the medical professionals, our victim does have to sign a medical release so we can receive that information. For the community partners, unless our client discloses and says, oh, you can talk to my counselor at this community agency, we might not know that they're working with them unless it's disclosed. We can always give the referral and that warm handoff, but it's up to our victim to choose if they want to participate in those services. And so for the victim witness division, here's a photo of the outside of our building. So we always tell our victims, if you have to come to court or have to come to our office for a meeting to find the victim witness building, it is going to be the one with the mirror of big boy holding a ohia plant. Our director, her name is Anna Malafu Eliesa. Right now, she is in a training in Kentucky, which is why she wasn't able to be here today. Including myself, there are 8 victim witness counselors, and we assist with cases involving crimes of violence. So that can include homicide, assault, sexual assault, abuse, as well as property crimes such as theft, burglary, and we are always available to answer questions in the community. So even if there's not even a case with the prosecutors, we want the victim witness office and our counselors to be a point of contact for the community. If you have a question, just want to know how the process is, maybe you have questions because you want to talk to someone else about their personal situation, we're always here and we always are available to chat. So we do have quite a few services available. So we do provide crisis and short-term counseling. More often than not, that might be during our initial point of contact with our victims. For example, a domestic violence case, we're calling them shortly after the incident when our office receives the police report. And for a person in crisis, that might be the time that they do want to let things out, let us know what's going on. We are able to provide that counseling, as well as referrals to social service agencies, case information and notification, court accompaniment, explaining the judiciary system and process, that return witness program that I mentioned earlier. We also are advocating for our victims' rights. So, because that rapport is built with us, our victims might feel comfortable telling their advocate that they don't really feel comfortable with this case. They might tell us, actually, I'm participating, but I don't really want to be here. And at least when they share that information with us, that's something that we can relay to the prosecutors to help better our services, our rapport for them, and just kind of see where they're at to move forward. We also assist with them filing those crime victim compensation applications. Oh, and I see we have a question. In a case where the victim was strangled but did not have surface injury at the initial reporting with Maui Police Department, but was later seen by medical staff and had internal injuries viewed by ALS, do you feel that this helps your case or harms your case because the first report didn't reflect injuries?
I think it would help our case. One of the things that we're trying to encourage police to do, and some of them do this, is we do want police to follow up with the victim within the next day or two, because there are many times when the injuries don't show up until the next day or even a couple of days later. I think it'd be great if every victim who was strangled does get seen by medical staff, and it's something that, you know, is important because there could be more serious internal injuries. But I think the fact that it wasn't reported initially probably doesn't harm our case, because I suspect that this is information that maybe a victim wouldn't know. Maybe the police, you know, who, you know, even though they're trained, you know, wouldn't be able to identify the internal injuries.
And so I'm going to be talking about in custody duty next, which is for domestic violence related cases, how our victim witness counselors are able to make our first point of contact with victims. So there are a rotating schedule done. So different advocates are having different days where we are reviewing in custody cases for the day. So essentially, those are a list of people who were taken into custody from the prior day or over the weekend if it's a Monday. So we review those and look for cases that have a domestic violence component. So those include abuse of family or household members, charges for the incident. So that could be a felony, a misdemeanor. It could include strangulation, non-strangulation, as well as violations. Violations can include a violation of a temporary restraining order, a protective order, which one is able to get from the courts after filing a temporary restraining order, or violation of a warning citation. So a warning citation is a situation where there is no active TRO or temporary restraining order in place, but there was an incident between two parties where the police decided that they need to cite with a warning citation. So they give that to the offending party and it will have a stipulated time, usually 48 hours, where they cannot come back or return to the home. And sometimes people choose to ignore that. They'll come back 30 minutes later, short time later, which is in violation. So our victim will be contacting the authorities, and that's how an offender is taken in for that type of charge.
Sorry, I just want to add with regard to warning citations, if there is an abuse where there's harm or bodily injury, the police have to issue the warning citation, and the separation period is really a time for a victim to get a restraining order if he or she wants to. And if it happens, if the abuse happens on a Friday, offices don't open until Monday, so the warning citation will usually be a little bit longer, 72 hours. And then we do have another question.
And then that's what happens when an offender violates a restraining order multiple times. And so for multiple violations, if it is an active restraining order, we always encourage our victims to contact police. So a report can be filed. Therefore, our office is able to get that information and review it for prosecution. So sometimes there are situations where someone is having an active case against them for violation of a temporary restraining order. And while the case is still active, unfortunately, there are other violations coming in.
And then sometimes if someone cannot follow the restraining order, cannot follow court orders, and starts picking up new cases, prosecutors will likely ask that a higher bail be set, or even that the person be taken into custody because they cannot follow the court rules, orders while they're out on bail.
And so the first time that going back to the slide, the first time we are as a victim witness counselor contacting our victims, like Shelly mentioned earlier, our main goal is check in for their safety. How are you doing? What can we do to help you in your situation right now? And our victims do sometimes want to talk about what happened. Sometimes they say, oh no, I'm good. I would like to drop the case. So it's kind of our way of finding out where their head is at. Sometimes they might change their mind during a later conversation. Sometimes their reaction is a trauma response post-incident, since it is shortly after. So we just have to be cognizant and understanding of that. But we always want to confirm that their contact information is correct, so they don't get lost in the shuffle, and we're able to reach out to them as this case moves forward. As needed, provide those resources and referrals, and just kind of getting more background, what's the history with the offender? Has this happened before? Do you guys have children in common? Are there any substances involved? So we do ask these things, and the client has the ability to disclose how much they want to share. So we have a question: isn't it dangerous time for the victim sometimes? I think sometimes it escalates, doesn't it? Yes, so it can be very dangerous post-incident. The good thing about this first call for these situations is, unless an offender has bailed out, we are able to talk with the victim in a space away from the offender. So when we are speaking with them, we are able to provide information about custody, as well as help sign them up for custody notifications. And then, how do prosecutors from different counties work together to deal with a Tier O violation or criminal other suspect who flees the island after a crime and ends up in another county? It's hard to prosecute due to the person now being out of their county's jurisdiction, but still within the state.
So normally what happens is when we file charges, people are usually bailed out. If we file a charge, they don't show up to court, there's a bench warrant for their arrest. Sometimes it's a penal summons, where it's just when they're served, they're ordered to come to court. I guess I would say, if someone is a high priority offender, we can work with, the other prosecuting attorneys, to as well as the other counties' police, to try to locate the offender. But many times, I think when there is a warrant out, we are waiting for that person to be arrested. So yeah, I mean, if someone flees, it is sometimes hard to get them to court. If someone is a high priority offender, we can work with the police here, who can also work with the police in the other county to go out and locate the person.
And so another thing victim witness counselors assist with are victim impact statements. I briefly mentioned it earlier. So the victim has the opportunity to speak directly in the sentencing hearing during court, to let the judge know about how the case affected them socially, psychologically, physically, as well as financially. Some people choose to submit in writing this statement ahead of time before the sentencing, which the judge will review prior to doling out their sentence. Sometimes they want to go in person to court and speak. And sometimes people are in a situation where they can't come in person. Perhaps they're on another island, out of state, or something, out of country. And as long as the court approves, then they can have that sentencing hearing be attended virtually and provide that victim impact statement online. If the victim impact statement is written, then the defendant also does receive a copy of that along with their attorney prior to that sentencing hearing. So at sentence, it's usually held several weeks after a conviction in a felony case, and there is a branch called Judiciary Special Services. And so they may be contacting the victim, just letting them know, are you requesting restitution? And then if there's other needs and concerns. And so those finances for that restitution are calculated and then provided to the court and defense attorney. And then that's what the judge uses to help determine if there should be a restitution amount at sentencing. And of course, if our victim is going in person to court, we're always able to accompany them to that hearing. And if they can't come, but just want an update, we'll also update them after. We also assist with filling out applications for the Crime Victim Compensation Commission for our clients. So this might be something that people are completely unaware of because they might say, oh, I was a victim in another case, but no one told me about this. And that's because certain crime classifications qualify for a application. So CVCC was created by the state legislature in 1967, and there are different versions of CVCC with different programs in all the states. In the US, DC, Guam, Puerto Rico, as well as the US Virgin Islands. For the date of incident, thereafter, a victim has 18 months to apply to the commission. But if someone's a minor victim, they do have more time. If there is a showing of good cause, for example, a letter from a therapist or doctor, there are some situations where a late application may be accepted, but that's on a very limited basis. So we always just encourage people to apply as soon as they're able to within that 18-month window. So here are some of the crimes where people are eligible to apply for. So if you are a victim of these cases and if it is involving a death, then surviving family are also able to apply. Some considerations when applying include, was a victim injured? Has the person responsible for the person who is responsible for the victim, for example, a guardian, have they suffered a loss? Perhaps they had to cover costs for therapy or things like that. Another exception is a Hawaii resident who's a victim of an act of terrorism, and that can be a baseline for applying. Sometimes there's surviving family who have medical or funeral expenses because of the decedent, perhaps through a murder or something like that, as well as dependents of a deceased victim. So that can be things like children. If a victim is unable to return to work after an assault, are they able to file for temporary disability or unemployment? So if someone does want to go that avenue, we do say, that is their responsibility to look into themselves because our office is not able to provide legal advice. So we can refer to the general things like the State Bar Association or legal aid if the situation would qualify. But ultimately, we have to let it go and then we just refer it out. And then looks like we're only have a little bit of time left, so I'm going to just breeze through some of these a little quickly. So there is a system through the statewide automated victim information and notification system called SAVIN. Some people call it VineLink. And basically that is a way for people to sign up and look about what the current custody status are for people that are in custody. Unfortunately, we can't look up people who are out of custody. So if there is an arrest, we always encourage people to go onto the website vinelink.com and follow the prompts to either check current status or sign up to receive notifications. And then other factors facing victims might be things like polyvictimization, because a client may not be disclosing that there's other things that they're going through that are unrelated to the case at hand. Also intersectionality, how does their race, gender, orientation, and other factors affect their life as well as their victimhood and how they are treated in the process. And then they also have to, as an advocate, consider the Maslow's hierarchy of needs. So essentially what this triangle shows is from basic needs going upwards. And so Maslow theorized that if the baseline needs are not met, then it is not feasible to try to work on things higher up within the pyramid. So I'll just briefly go over the bottom one. So that's physiological needs. Does our client have shelter? Are they able to get food? Those are the things that someone may have as their first priority. And then they're able to, once those things are secured, open up their eyes to see, are we able to go higher up in the pyramid and address these other issues? Sorry. How do you handle DV cases involving the disabled?
I don't think we, each victim is different. And I believe Chelsie was going to get to this, but we try to meet the victim where they at. So if there are certain needs of a victim, we will try to accommodate as much as possible. So I do recall handling a case where a victim did have difficulty meeting us at the office. We made arrangements to meet her elsewhere. That can be, at court in one of the private rooms, or even going to their house, or wherever they're able to meet us.
And then for protective factors, again, that's another thing to consider. And then how can we support effectively? We should be meeting our victims where they are at. It's a very stressful, really overwhelming experience that they're going through. You have to be very understanding that they might be negative, combative, argumentative, and we have to just know that that's part of their trauma response. It's not personal. We also have to be empathetic. Sometimes our clients are still under that wheel of power and control and want to support a defendant. And even if we personally disagree with that, we have to support the decision they make by being empathetic, even if we disagree with it. And we have to also maintain that support. So, like I said, they might choose to not want to create a safety plan despite us discussing it. They may choose to want to just not talk to us. But no matter what, we have to say, we are here if you need us. You don't want to talk to us, that's fine. But we just have to say we are open and ready whenever you are ready. And just allow these people to make their own choices at the end of the day.
So I think we're kind of getting towards the end, but I do want to talk about, domestic abuse laws and why they matter. I believe that, the participants at this conference know that domestic violence affects everyone. I've heard mention of generational abuse. We also understand that there's long-term effects on victims, not only maybe needs, but also, health problems. Domestic violence is a public health issue. It affects everyone in the family, whether they're the direct recipient of the abuse. Sorry, I see one more question.
Does Hawaii law allow for continued prosecution even if the victim changes their mind?
I believe we can go forward even if a victim changes, decides they don't want to prosecute. And one of the reasons why, we do go forward on abuse cases is, because responding to abuse calls can also be homicide prevention. And these are some old stats, but as you can see, a good number of the murders were a result of domestic violence. I'm going to skip over the strangulation and come back.
But if anybody does want to review it, you can go to Alliance of Hope, which offers the Training Institute on Strangulation Prevention information.
And the reason why I wanted to kind of just go through that, and we can provide a link for the that organization, is I did want to get to my hope in being at this conference. And I do appreciate the opportunity to share our experiences to help build relationships or reinforce relationships. But I believe that we can better address domestic violence if we can develop a coordinated community response. And I believe some counties on the mainland have done this. And this is, and Maui County is great. I think we work well together with police, our community partners, but there's nothing formalized. And I think a community response would be a formalized response involving police, prosecutors, advocates, probation officers, counselors, the court, judges, and it would allow us to implement a procedure that would improve the way we respond to domestic violence and lead to a more uniform response. Also bringing in people from the community allows us to provide a better support network for our victims. The criminal case may end, but the support that Chelsie provides, other advocates provides, doesn't end. So I'll let Chelsie talk a little bit about expanding our network.
Yes, so we do want our victims to feel comfortable reaching out to us after the case is over. Sometimes it's a year later where someone might call and say, oh, this thing happened and I want to talk about it, ask about it. Sometimes, we're able to listen and say, oh, is this a situation where you want to file a temporary restraining order? Are things escalating where it's an incident you want to file a police report? So sometimes it's just touching base. With that rapport, they feel comfortable reaching out to us. So that's always great to hear back from them. Sometimes we are supporting them in situations that are kind of beyond the criminal case. For example, a child might not have witnessed the incident, but as a parent, they want their child in therapy. So we might be helping with that as another example.
And again, we can always do better. Training, education helps. Having our deputies, our office trained in trauma, the dynamics of domestic violence, even going out into community and talking about domestic violence and what we do, what we see. I know someone just asked about whether we go ahead, even if the victim doesn't want to prosecute. And my goal is that we are able to prosecute these cases, even if the victim says, I don't want to be there. And the way we can do this is to focus on the evidence, have the police gather corroborating evidence. So, good photos, the 911 call, the body worn camera video showing how the victim looked, was acting, when they first responded. Many times victims will call someone else before they call the police. So finding out who that person is, what they were told. Also, statements from medical professionals, injuries they observed or what kind of treatment the victim received, as well as jail calls. You'll be surprised at what an offender defendant may say over a jail call, even if they're warned that the jail call is recorded.
So ultimately, at the end of the day, we always should be doing more. And so besides just doing more, here's a little acronym. So we should help by documenting, observing, always encouraging our victims to seek medical attention. If it is a situation where, perhaps it's mental health medical attention, perhaps it's physical injuries. Also, just offering hope. And we can do that by providing education and providing those resources, assessing for risk, and lastly, continuing to educate. And so we're available if you guys have any other questions in the meantime. And like Shelly said, after this presentation, we will be sharing the resources we have in regards to strangulation.
Thank you, Tina, for sharing that link. So it looks like we're good. Yeah.
Okay.
Thank
you
you,
guys.
everyone.